Segal would like to welcome you to today's webinar presentation. This is our Attorney Roundtable. This is the third, actually, of a webinar series within our National Fiduciary Liability Insurance practice. Now I would like to introduce our speaker. We have Brian Smith. He is our Senior Vice President within our Fiduciary Liability Insurance practice. And now I'll turn the call over to Brian.
Thank you, Liza. What we want to talk about today, primarily, as in many of these discussions, a lot of the focus is on the fiduciary liability. That has always been the core product of our unit. It's a product that's very important for our mutual clients, the trustees of these benefit plans. But we've also have expanded into other core products, which include the fidelity bond, employment practice liability, and cyber. So we will also be talking cases that might be of interest that involve those products as well. And then finally, I found this final case, USA versus Apple, which just intrigued me, so I think we're going to talk about that or present some material on that a little bit. Before we really get going, and particularly with you as my audience, as attorneys, our normal Segal caveats: we are not a law firm. We do not practice law. I am not an attorney. All of my experience is simply based upon insurance brokerage experience. We are not an insurance carrier, and we do not provide binding interpretations of coverage. Only a carrier can do that. I decided to start with 408B2, new federal regulation. We all went through the hassles of trying to make sure that the proper documents were filed with all of our clients on a timely basis. But when I looked at it, what I kept on seeing was the issue of transparency and compliance. More and more we're seeing the regulatory authorities demanding greater and greater transparency, and we're seeing more and more regulations that even have been issued or are being proposed for issuance that's demanding greater transparency. There was one case that we have seen, and it was an investment advisor, and the Labor Department has fined them $1.7 million because they were taking some extra fees out of the way they were doing their work that hadn't been properly disclosed. And the point I think I'm trying to make is, from what we're seeing, I believe the regulatory authorities are just going to continue to be very strict on this theme and continue to develop this theme. And I think we just have to make sure our clients really start to look at the issues of transparency. Are they getting the correct disclosures from everyone? Are they in compliance? And I just think this is an area where a lot of potential fiduciary exposures are going to develop, because at least for our multi-employer clients where plan assets can't be used to pay fines or penalties, a lot of these policies are going to be looked for to respond on that type of an issue. Another really basic one I thought spending a couple of seconds on are claims notices. We're seeing a great increase in the frequency of claims, and in some instances we're seeing late notices. We're seeing attorneys who have been retained without consent of carrier. We're seeing legal bills being incurred where the carrier hasn't agreed to them. It's just a really good stopping point here to look back as legal counsel, and I'm going to argue to a certain extent, ultimately you are always going to be held or looked for responsibility in reviewing any contracts, and these policies are, after all, contracts, that we've got to make sure our plan administrators particularly really do have a basic sense of what constitutes a claim, whether it's under the fiduciary or any of these insurance policies, and what are the obligations that come out of these policies that have to be complied with. One of the examples I'm giving is the DOL investigations. We are seeing some investigations, and you get the notice letter, and it's 6 to 7 years later before there's a resolution. Well, if we finally file a 10-day letter 6 years or 7 years after the audit has begun, are we going to wind up with a late notice issue? And whether that's going to be material. We've taken the position, let's just file these notices early, get them out of the way, even if the carrier declines them. We've given you some highlights I've been talking about making sure there's an understanding of the definition of claim. The 8th one, please copy us as the broker so that we have a record of the claim and we can track it and put into our diary system. But the rest of these, I'll let you, you can go through them. If you have any questions, please come back to me.